Welcome to the deep dive. Today we're tackling a really important topic, mental health advance directives.
Yes, MHADs.
We'll be exploring how they play a role in, well, respecting autonomy for people with mental health conditions.
Exactly. They're essentially a way for individuals to put down their preferences for future treatment.
For times when they might not be able to make those decisions themselves.
Precisely. It's like leaving instructions during a time of well-being for a potential future crisis.
That's a great way to think about it. And for this deep dive, we're using some really interesting source material focusing on the legal side, the policy developments.
All based on the document you mentioned, yes.
Yeah.
Looking at it internationally.
Right. So our mission today is to kind of unpack all the complexities, look at the legal stuff, the ethics,
How they can empower people.
and the challenges too. How different countries are actually handling this.
There are definitely some surprising variations out there. Balancing autonomy and protection is, well, tricky.
Okay, let's dive in. Where do we start? Foundational principles.
Yeah, let's start there. The whole idea of choice in healthcare, it's evolved quite a bit.
How so?
Well, initially, it was very much about pushing back against, doctors always knowing best, the right to refuse treatment.
Ah, okay. So the power to say no to something, freedom from intervention.
Exactly. But that's broadened out now, hasn't it?
Seems like it. To a wider sense of autonomy, making your own decisions, maybe even accessing services, but it's not always straightforward.
No, not at all. The source material flags how sometimes choice gets framed in a sort of neoliberal way, like you're just a consumer choosing a product.
Right, like shopping for healthcare.
Kind of. And social science critics, people like Baudrillard, Nussbaum, Gabe, and Kalman, they question how meaningful that really is for health.
Because health isn't just another commodity.
Precisely. Is it real choice or is it tangled up with, administrative goals?
Interesting point. So this consumer idea might not fully capture it. What about the human rights angle? That seems more robust.
Definitely. Human rights puts the emphasis squarely on respecting a person's integrity, physical and mental. Your views matter.
Like in that case, Racely, the man who refused amputation.
Exactly. The court respected his assessment of his own life and well-being, not just the purely medical facts.
So it's about values, lived experience, not just clinical data. It challenges that doctor knows best idea.
Totally. It acknowledges the subjective side of these decisions.
And the source also mentions something about the shadow of civil commitment laws, how that affects voluntary treatment.
Yes, that's a really crucial point. People worry, understandably, that these laws, the ones based on potential danger, might make doctors or others view their attempts to discuss or refuse treatment differently, like seeing it as non-compliance.
So trying to engage in your care could actually backfire.
That's the fear,
Yeah.
that it could lead towards more coercive measures. Bernstein, Russo, and Wallcraft really highlighted this chilling effect based on people's experiences.
Wow, that's a difficult position. Needing care, but afraid to fully engage. How does the right to health fit in?
Well, the right to health is seen as this integrated platform. It pulls together different kinds of rights.
Civil, political, economic, social, cultural, all of them.
Exactly. Historically, they were often treated separately, but the thinking now, drawing on things like Article 12 of ICSCR and Article 6 of ICCPR,
Okay.
is that they're all interconnected. States have obligations to respect, protect, and fulfill this right. It's holistic.
Got it. Okay, let's move to the Convention on the Rights of Persons with Disabilities, the CRPD. You called it a paradigm shift. Why so significant?
It really was, because it directly confronted how people with disabilities had historically been, well, left out of human rights discussions. Quentin DeGeneres' work points this out.
So it wasn't just applying old rules, but creating something new.
In a way, yes. It centers the specific perspectives and needs of people with disabilities, moving beyond just a medical view.
Focusing on societal barriers instead.
Exactly. Lawson emphasizes this focus on participation, remedying that historical absence of disability voices in law and health. And unlike earlier declarations,
The ones from the 70s.
right, those weren't binding. The CRPD is. It creates legal obligations for countries that sign on.
And you mentioned it bridges the gap between different types of rights.
Yes, that old split between civil political rights and economic, social, cultural rights. The CRPD, like the Vienna Declaration, says they're all indivisible, interdependent.
Which makes sense for disability rights spanning so many areas.
Absolutely. Which brings us to Article 25 on health.
What are the key points there for MHADs?
Article 25 is huge. It guarantees the highest attainable standard of health without discrimination. Same quality, same standard of care.
And services specifically needed because of a disability.
Yes. And crucially, for our discussion, it mandates free and informed consent.
So consent is central.
Absolutely. And it obliges health professionals to respect autonomy and dignity, requiring training to ensure they do.
It really sounds like a push towards a person-centered, rights-based approach.
It is. And it links up with wider ideas, too, like the social determinants of health.
The WHO's work on that. Income, education, living conditions.
Right. The CSDH, the Rio Declaration, they all stress that health isn't just about doctors and hospitals. Social factors play a massive role, especially for people with mental health conditions.
And this ties into the social model of disability. How does that challenge the medical model?
The social model is a powerful critique. Instead of seeing disability as an individual problem, a pathology to be fixed.
Which is the medical model view.
Pretty much. The social model says disability is created by society, by barriers, attitudes, inaccessible systems.
So a problem isn't the person, it's the environment.
Largely, yes. Thinkers like Friedson, Oliver, Barber pointed out how the medical model can be paternalistic, framing difference as disease. The social model shifts the focus to removing those societal obstacles.
That's a fundamental shift in perspective. Okay,
Yeah.
Next point. Non-discrimination and informed consent being intertwined. How do they relate?
Well, non-discrimination law itself has evolved. Started with formal equality, treat everyone the same.
Which doesn't always work in practice.
Right. So then came the substantive difference approach, acknowledging different groups might need different treatment, sometimes positive discrimination, to achieve real equality.
And now?
Now the push is more towards mainstreaming, designing systems that are inclusive from the start, so difference isn't seen as separate.
So how does the CRPD's equality principle challenge mental health law, specifically on consent?
It forces us to ask, why is the treatment often different for people under mental health law versus general health law, especially around consent?
We need to compare them.
Yes, a critical comparison. Are the differences justified? Do they align with non-discrimination? The CRPD really pushes that question.
Which leads us straight into assessing capacity. That's notoriously complex in mental health. The Ray M.B. case.
Yes, Ray M.B. tried to define irrationality in decision-making. Dame Butler-Sloss talked about a decision so unreasonable no sensible person could make it.
But she added caveats.
She did. Cautioned that panic, indecision, even irrationality don't automatically mean someone lacks competence, though they might be flags.
And she linked competence level to the seriousness of the consequences.
Right. Bigger decision, maybe higher competence needed, but the source rightly flags the risk of circular reasoning there.
How so?
Well, whose view of the gravity of consequences are we using? It could subtly bias the capacity assessment itself.
It's a delicate balance, definitely. And the source stressed the importance of providing information for consent, something often overlooked.
Hugely important. Capacity isn't just about being able to understand, it's about actually getting the information needed to make a real choice.
Like in those U.S. cases, Schlondorf, Canterbury v. Spence.
Exactly. They link self-determination directly to getting understandable information. In mental health, that means more than just clinical facts. It's about engaging with the person's values, their life.
And this all bumps up against the tension between autonomy and protection, right? Articles 16 and 17 of the CRPD.
Yes, those articles cover protection from harm and the right to physical and mental integrity. The key is an integrated human rights analysis.
It's not either.
No. You have to balance respecting autonomy with the state's duty to protect vulnerable people. It requires nuance.
Okay, let's shift gears to the historical context. The source mentions changing views on mental illness and, well, some pretty dark history in the U.S., like Buck v. Bell.
Yeah, that history is vital background. There was a shift towards more biological views, sometimes tied to eugenics, the social hygiene movement.
Which led to things like compulsory sterilization.
Tragically, yes. Buck v. Bell upheld that. A really awful period. And think about treatments like electroshock, psychosurgery, often done without real consent.
A stark reminder of potential abuses. Then came the anti-psychiatry movement. What's their critique?
They radically questioned the whole concept of mental illness as just a biomedical disease. People like Saz, Ling.
What do they argue?
That maybe madness had its own meaning, that psychotic experiences weren't just things to be suppressed, maybe even part of healing.
So challenging the medicalization of social or existential issues.
Pretty much. They drew on sociology, Goffman, Foucault, looking at how institutions construct illness through power dynamics and social control.
A fundamental challenge to the system. And during this time, we also saw the rise of the mental health bar,
Mm.
pushing for rights.
Absolutely. Lawyers like Bruce Ennis were key. They fought for principles like the least restrictive alternative.
From cases like Lake v. Cameron.
Yes, meaning you choose the option that interferes least with liberty and autonomy, roots in cases like Shelton v. Tucker.
And the right to treatment.
Also crucial from cases like Wyatt v. Stickney. If you're committed, you have a right to adequate treatment.
Then came deinstitutionalization. How did that influence interest in MHADs?
Well, closing large institutions was driven by rights victories and awful conditions, but
There were unintended consequences.
big time, often not enough community support. This gap actually spurred interest in MHADs, or PAs, as they were often called in the U.S.
As a way for people to have more control in the community.
Exactly. By the mid-2000s, all U.S. states allowed some form of advanced choice, many with specific MHAD laws.
And Hargrave v. Vermont.
That case struck down discriminatory limits on using advanced directives just for mental disorders, based on the ADA, a big win for equality.
Okay, fascinating history. Now, let's look at those international case studies, starting with Ontario, Canada. Their consent and capacity law.
Right. Ontario's framework is interesting. Cases like Millett v. Schulman set the stage for general health directives, and Fleming v. Reed affirmed bodily integrity and mental health.
Leading to the Healthcare Consent Act.
Yes, in '96, aiming for a system respecting prior wishes through substitute decision makers if capacity is lost.
But it wasn't simple. The AMV Beans case.
That case showed the tensions. How much power does the substitute decision maker have versus the consent and capacity board?
And the role of best interests.
Exactly. The court said the board could consider best interests, including prior wishes, but it sparked debate about how much weight those prior wishes really get.
And the Conway litigation highlighted similar issues.
Yes, Conway's case and Starson v. Swayze too. They really tested applying capacity rules to advance instructions, especially about specific treatments.
So, a tension between the person's stated wish and a later best interest assessment.
That's the argument some make, that courts sometimes leaned more towards best interest than maybe the law intended, potentially undermining autonomy. SMT via Boulinars is sometimes mentioned here.
And Canada put a reservation on substitute decision-making when ratifying the CRPD.
They did, which underscores these ongoing legal and ethical knots.
You also mentioned delays in cases like Conway and Starson. Why is timely adjudication so important here?
From a human rights view, delays are a big problem. People can be stuck in limbo, maybe detained longer than necessary, or their health declines while waiting for a decision.
The European Court emphasizes speed in health matters.
Very much so. Timely, effective remedies are seen as fundamental. We'll get more into the ECTHR later.
Okay. Let's cross the pond to England and Wales. Big influence from the European Court and the Human Rights Act.
Huge influence. The Human Rights Act brought the European Convention into UK law. Article 3, prohibiting inhuman or degrading treatment, is key for medical treatment, as seen in Pretty v. UK.
And specific vulnerability for the mentally ill.
Yes. The ECTHR recognized that in Herzog-Falby v. Austria, these rulings pushed reforms like changes to the Mental Health Act and the Mental Capacity Act 2005.
What about capacity and consent in English common law, the Bolam principle?
English law distinguishes between those with and without capacity, but historically the courts were cautious about giving people with capacity an equal say. Bolam is the classic example.
What did Bellum say?
Essentially, a doctor isn't negligent if they follow a practice accepted by a responsible body of medical opinion, even if others disagreed.
So, deference to medical consensus.
Pretty much. Lord Scarman, dissenting in Sidaway, worried this sidelined informed consent from the patient's view.
Has that shifted?
Somewhat. Cases like Chester v. Afshar lean more towards autonomy. But there are still limits, like in the Burke case, suggesting doctors don't have to give treatments they think are clinically adverse.
So, still a balancing act. What about MHADs, specifically in England and Wales?
The Mental Capacity Act 2005 allows advanced decisions to refuse treatment, including mental health treatment.
But they can be overridden.
Under the Mental Health Act, yes, in certain circumstances, like preventing harm. Interestingly, NICE-E guidelines support MHADs.
But maybe limited in scope, beyond just clinical stuff.
Possibly. But courts, like in Ray M., are taking a broader view of best interests when someone lacks capacity. They must consider wishes, feelings, human rights.
So MHADs should carry weight, even if the law isn't perfectly aligned yet.
That's the direction things seem to be moving, giving those wishes significant weight.
Okay, let's head north to Scotland. Comprehensive reform there with the 2003 Act.
Yes, Scotland's Mental Health Care and Treatment Scotland Act 2003 was a major overhaul. It introduced advanced statements,
What are those?
formal documents where people state their preferences. And crucially, the law puts a duty on decision makers, tribunals, clinicians to have regard to them.
Have regard. What does that mean in practice?
It means they have to seriously consider it, and if they override it, they need to provide written reasons.
Reasons given to the person and the Mental Welfare Commission.
Yes, exactly. The commission plays a key independent oversight role.
Does this framework give full recognition to choice, though? More than England, Wales.
It's definitely stronger, but the source suggests maybe it still falls a bit short of automatic recognition of choice, as some hoped.
But the monitoring helps.
Absolutely. The oversight by the commission is vital. And that review by Riley and Atkinson was interesting.
What did it find?
That most statements were clear and specific, countering fears about ambiguity, and refusals of all treatment were rare.
And Scotland has a broad definition of treatment. How did that affect advanced statements?
It's significant. Treatment isn't just meds or therapy. It could cover accommodation, daily life stuff.
So statements could cover those broader things.
Potentially. The source argues maybe overrides in those areas should also trigger notification to the commission, just like clinical decisions.
To strengthen their impact.
Exactly, to make them more effective across the board.
Right. Lastly, for case studies, Australia and New Zealand, less developed law and policy here.
That seems to be the consensus. New Zealand has its Bill of Rights Act, and the Mental Health Commission promotes MHADs, aligning with the CRPD.
But Australia's federal system means variation.
Yes. Different states, different paces. There's been national policy development, a statement of rights.
But slower on specific MHAD laws.
Generally, yes, compared to Canada or the UK. Though there's renewed interest, partly linked to end-of-life care debates and the CRPD ratification.
So some states might be moving towards legislation.
It looks like it. Some draft bills have proposed recognition, but overall, it's seen as an earlier stage of development there.
Okay, that covers the case studies. Now, the European Court of Human Rights, the ECTHR, and the right to choose, what key ideas come from there?
The ECTHR has been very influential. Pretty v. UK, again, refusal of life-prolonging treatment falls under Article 8.1, the right to physical integrity.
But not an absolute right.
No. Article 8.2 allows limitations if they're lawful and necessary for a legitimate aim, like protecting health. The court wants clear, flexible laws.
And Tysiak v. Poland, what did that add?
That established a positive obligation on states. They have to provide timely, effective ways to challenge health decisions. Rights must be practical, not just theoretical.
And Glass v. UK seems really relevant for substitute decision-making.
Highly relevant. It said you generally need court authorization to override objections made by an authorized decision-maker for someone lacking capacity.
Establishing a kind of limited right to choose even then.
Yes, and emphasizing the substitute decision-maker's right to participate. Overall, the ECTHR stresses self-determined freedom, dignity, participation, giving weight to the individual's view.
Okay, last main point. Broader considerations and the potential of MHADs. The source notes the vulnerability of people with mental health conditions.
That's a vital starting point. Higher risks of violence, abuse, homelessness, rights restrictions. It's a reality.
In ECTHR cases like Johnson and Stanev address detention.
Yes, they stress safeguards against arbitrary detention, the need to consider individual well-being and community safety, plus that Council of Europe recommendation.
About maximum reservation of capacity.
Exactly. Principle 3 says that applies to healthcare consent too. Preserve capacity as much as possible.
And Patrick's case in Australia, PJB v. Melbourne Health.
A great illustration. Even with guardianship, the court emphasized respecting Patrick's wishes about where he lived, giving them significant weight, least restrictive options.
Showing how MHADs could fit into that, preserving the person's voice.
Precisely. They facilitate communication, give substance to rights.
So what's the ultimate potential here?
Richard Bonney argued MHADs could help shift the whole system towards recovery. More collaboration, less coercion, structuring crisis responses based on prior wishes.
And overriding a valid MHAD needs strong justification.
Absolutely. Human rights grounds, carefully justified. Treatment during crisis should still follow wishes, proxy decisions, or the MHAD whenever possible. Equality, non-discrimination demanded.
Compulsory care without reference to wishes is against human rights.
That's the standard. MHADs help identify agreed approaches. And remember, capacity is functional. decision-specific.
So we should interpret decision-making ability generously.
Yes, Briseau and Applebaum's work supports that. MHADs are communication tools, even when talking is hard.
And they should cover more than just medication.
Ideally, yes.
Yeah.
Accommodation, support. Reflecting the breadth of mental health law and the importance of social and economic rights for well-being. It moves beyond just the purely clinical focus of something like the Bolam principle towards proportionality and the individual's perspective.
Okay, wow. That was a really thorough exploration.
Yeah.
Let's try and sum up the key takeaways for everyone listening.
Well, I think it's clear MHADs are a really crucial tool. They help uphold autonomy rights within a really complex legal and ethical world.
In international human rights, plus all that case law, they're pushing towards recognizing the individual's voice more and more.
Definitely. For me, the aha moment is seeing that journey from just the right to refuse treatment to this much more comprehensive idea behind MHADs. It shows a deeper understanding of autonomy, participation, non-discrimination.
And it's fascinating how different countries are approaching it, the variations.
But also that consistent push towards respecting preferences, it's really striking.
Absolutely. Though we have to acknowledge, right, that putting them into practice effectively,
Yeah,
that still faces real challenges.
for sure. Which leads to a final thought for you, the listener. Given these varying legal standards, this growing emphasis on individual wishes, how do you think mental health care might evolve further to really center the person's autonomy, even in a crisis?
And what role could things like technology or maybe better community supports play in making MHADs even more impactful?
Yeah, something to think about. We definitely encourage you to maybe look into the laws where you are and the work disability rights groups are doing. It's a really vital area.